What if I told you that most loans are not backed by lawful consideration, only the appearance of it? And what if I told you that the signature they needed was the funding they never disclosed? What we're about to talk about is lawful consideration, the missing piece when it comes to private banking and debt discharge. Okay? Banks don't use money, they use your promise. People say that banks lend you money, but when you ask, where did the money come from? Who funded it? Whose asset was risk? And typically those answers disappear. Typically, the truth is very simple. What happens is the borrower funds the loan by signing the instrument. The bank monetizes it, and the system calls this lawful consideration, even though it looks nothing like what the law requires. But you and I both know that when we're thinking of a contract, it should be an equal value exchanged. And today I'm not here to tell you that their credit extension is not a value exchanged, even though we can agree on that. I'm going to teach you guys how to be able to understand the element of consideration as it comes to legal reality and how to use it to your advantage. I think the problem is we don't understand that reality and illusion can coexist. So we do know that it's an illusion that they risk their own money, but the reality is that the courts look at the credit extension as lawful consideration. So how do we get around that? All right, so I'm doing a 5-part series towards the end of this week explaining consideration for what it really is, so you don't get confused, mystified by the concept, because it is a super important concept when it comes to contract law, and it will help you when challenging debt, validating debt. Now, before we dive into the video, remember to hit the like button, hit the subscribe button, tap into the channel, okay? You invest in me, I'll continue to invest in you. Number 2, this is not legal advice. This is not financial advice. Remember to do your due diligence. Remember to do the research on your own. You understand me? So, thank y'all for watching the video. Let's dive into another one. All right, bet. So, the first question that we're going to ask, or that one would ask, is, Nicholas, what are you talking about? What is consideration? Okay? Now, let me give you guys the real legal definition of consideration. Okay? Now, if you wanted to obviously dive in more into contract law, you'll find that in the restatements. Okay? And it says that consideration, let me do this real quick, because I just want the Google definition. In layman's terms, Google says that in contract law, consideration is the value exchange between parties, which can be money, goods, a service, or a promise to do or not to do something. Okay? So what I'm about to talk about is this is the actual law. This is not fantasy. Okay? So when you are challenging contracts, there may be an element of what it may make you feel like this is not something that you can challenge them on. But the reality is that why would they have a whole documentation specifically talking about consideration? It says, Restatement, Second of Contract, Section 71, consideration, the requirements of an exchange, types of exchange. Number 1, to constitute consideration, a performance or a return promise must be bargained for. A promise or return promise, they must be equal. It must be an equal bargain, okay? The performance may consist of an act, a forbearance, or the creation, modification, or destruction of a legal relationship. So in translation, both sides should give something of value that is exchanged and mutually recognized. If one party gives nothing, or the value is an illusion, the contract collapses. And this is where banking becomes tricky. Because here's the thing, right? Reality the truth says that when we just understand the element of consideration, both sides must give something of value that is exchanged and mutually recognized. But I didn't recognize that I gave you something that was even more value of what you would give me. You get what I'm saying? Because what value? Okay, the value that I got was this house, this vehicle. Okay. Did you give me the car, or was that a benefit? because you was going to be able to take my promissory note and make more money off of it. So you just gave me the car. But if you would have just gave me the car and didn't try to collect after the fact, then the reality is that you gave me value and I gave you value. Why doesn't that matter in court? Is what we understand, what we kind of, come to the conclusion and even at times get emotional about, get frustrated about, simply because we understand that this reality. We understand that when you're thinking of a consideration literally means that equal value is exchanged. And if one party exchanged value and what they got wasn't exactly what they mutually recognized that they was going to get, they end up not only doing that, but having to give more. That is not a mutual agreement, okay? Now, before we dive into that, I want to talk to you guys a little bit about the Fund Yourself Academy. Now, we are live streaming on Twitch, okay? And my live streams on Twitch it's when you can chop it up. It's more casual, you know what I mean? Not really much back and forth, interaction. But when we're talking about the Fund Yourself Academy essentially allows us to be able to communicate, allows us to be able to compound. Another thing that it provides is the ability to have resources to understand things like consideration. When I put together this 5-part series, I'm going to put together a workbook that you can be able to go review and attach with this series, and it'll be included in the school community. The school community has classrooms, videos, courses, resources, and templates that you can be able to tap into. All right? Tap into the Fund Yourself Academy. I said that I was going to go up to $27, probably to $47. But until Christmas, the Fund Yourself Academy is going to stay at $27 a month. Tap into the Fund Yourself Academy and learn how to fund yourself today. Now, back to the regular scheduled program. Did the bank actually give you value? Is a question that no one truly asks. Did the bank give lawful value under Section 71 of the second restatements, the restatement of second contracts? The value must be real, tangible, and risk in order for it to be considered value. Now, we're definitely diving into the equity side. The closer you are in the conversation of equity, obviously, this information is going to work much better. All right? I'm trying to preface this very early, 10 minutes into the video, so that you don't just see this video and immediately get excited at the fact that consideration, I'm going to start gunning for that. It's going to enhance your argument, not make your entire argument, okay? But the reality is that because it's not real, tangible, and it wasn't necessarily risk, it was an accounting entry, it was credit creation, it was bookkeeping, right? That's not considered real value under Section 71, okay? The bank cannot lend its depositors money. That is under the Federal Reserve. The Federal Reserve makes those rules. And it also says that under 12 CFR, okay, which is the Truth in Lending Act. All right. And a bank cannot lend its own credit. So here's the reality. The banks do not risk their own assets. So here's the question. If the bank didn't give real value, who did? If the bank didn't give real value, who did? And this is not for my people who already know the answer to this question, but it is to make you ponder. Okay, there's people who don't know the question, but for the people who are still like, okay, bet, why would I even do this? Help me understand this. So now we got to figure out who gave the value, and the value is you. You did. Because when you signed that promise became a negotiable instrument under UCC 3-104. Okay? So, perfect. That really takes me to my next thing. What is a negotiable instrument? A negotiable instrument means a unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in a promise or order if it is payable to the bearer, payable at an indefinite time, or at a fixed rate. Okay? Here's the thing. I want to highlight this real quick, negotiable, all right? I want to highlight negotiable because a lot of people think that negotiable instrument means that that's just the completion of the debt, okay? It's the start of negotiation, just just to bring the forefront of the reality. A coupon, negotiable instrument. A promissory note, negotiable instrument. A bill of exchange, negotiable instrument. Or anything that is an unconditional promise or order to pay a fixed amount of money is a negotiable instrument. A negotiable instrument. Now, once you submit that negotiable instrument, it is up for negotiation. What is going to be done with it? Do you guys gather that? Do you guys understand that? So before one dives in and tries to use a negotiable instrument, first understand that it's just the promise to pay. It does have value. It does give them the ability to be able to create credit when you submit a negotiable instrument. But I don't want to jump the gun yet. Okay? So understand, when you sign a promissory note, you create a negotiable instrument, which in Article 3 says that it is a financial asset. It's a security. Okay? It's just like a check. All right? It's a financial instrument. Then we dive into the next part, which is UCC 3-105, essentially says that once it is issued, the instrument has value. Okay? So what is issuing? Issue means the first delivery of an instrument by the maker or jar, whether to a holder or non-holder, for the purpose of giving rights on the instrument to any person. An unissued instrument or an unissued incomplete instrument that is completed is binding on the maker or jar, but non-issuance is a defense. An instrument that is conditionally issued or is issued for a special purpose is binding on the maker or jar, but failure of the condition or special purpose to be fulfilled is a defense. Okay? So it does say that once you issue it, okay, then the instrument has value. But let's just say it's incomplete or not properly issued. They can use that against you. Okay, so that's why it's important for you to write a letter with your negotiable instrument. Explain to them what it is that you are doing and what you want them to do. But then there's also the element of the conditions, the negotiation aspect. Okay, everything is up for negotiation. It's just business. All right. Just like you are negotiating that debt so you don't have to pay it, they are negotiating so that they can continue to get paid. All right. But here's the thing. Your signature creates a new asset. The bank deposits that asset, which is called a mere liability, and that deposit becomes the source of your loan. And this is what we are arguing about. This is what most people, I included, get upset about. The fact that we are creating the asset. You're giving us back what we gave to you, and now we're paying on it. So the question is, who funded the loan? The borrower, okay? And this is the part that will always put you in a position to win. The fact that they never disclosed that. The fact that they never told you that. Okay. I hope you guys are gathering that. Now, here's where we start to bring the more legal truth to help you guys utilize that missing piece that then puts you in a position to win just by using debt validation, just by using conditional acceptance, just by challenging them, because this simply violates the Truth in Lending Act. Okay? And the Truth in Lending Act explains everything that has to do with the source of credit, the true costs, the actual lenders, and this is something that they must disclose. Okay? Under 12 CFR 1026, okay? These are regulations in commerce. And then we dive into 15 U.S.C. 1681. 15 U.S.C. 1681 is also the Truth in Lending Act. And this is your rights. You have a right to meaningful disclosure of credit terms. So one of the terms is that we are going to take this asset, mirror it, and make you pay for something that you gave value on. That's something that should be disclosed. Or better yet, because of that right there are some things that you probably won't be able to disclose. You probably won't want to disclose, which is why the Truth in Lending Act is going to be so powerful. Because when I ask you for particular disclosures, there is no limit to what I can ask you for as it pertains to the loan. So if I asked you about securitization, where the money went, and X, Y, Z, if you charged off the debt, if insurance paid it off, if I asked you for that, because we do know that this all happens. We do know that they are mirroring a liability. It gets cleared by the Federal Reserve. No money is really lost. They did a service. And sometimes I can make it to where my intention is so that I'm only paying for the service and not paying for something that you claim you loaned me. Does that make sense? I want to make sure that I'm performing on the contract, not paying unknowingly and unwillingly just because you said that you loan me. If I have to pay you, there's a thing called a finance charge, which should be disclosed in the Truth in Lending Act. That is the true cost of credit. That is the sum of all charges, if you want to keep it a buck. So why am I not paying that? Valid questions to ask, okay? Just because you created credit don't mean that I have to pay you all of that back. Does it have a value when I pay, or does it have a value before I pay? Because it's based on my labor. And it's not like they are really tracking the labor that I do. It's going to have value anyways. And we know this, all right? You fund the loan with your instrument, and the lender has the duty to disclose, but they never do. Go back and watch my series last week where I talked about disclosure and how important disclosure is, and that is exactly why we win, because they do not properly disclose information that they should disclose, all right? The lack of disclosure creates the appearance of consideration, but not lawful consideration. So here's the other thing that people don't tell you, that when you ask them to provide certain disclosures and they do not give it to you, that is also them not exercising on their duty, because their consideration is the service that they bring to you. So if part of the service is them disclosing information to you, then that's what they should be doing, or else it isn't an even exchange. If I promised to pay this loan and give you a negotiable instrument, you are now a service to me. You have to provide a service. And if one of the services, okay, can you tell me about this loan? Can you disclose some information about this loan? Yeah, I got a vehicle, whatever the case may be, but I know that you guys get value up front. So let's just make this make sense. Okay. So before you get excited about this though, is this fraud or is this just modern banking? The reality is that the courts, we can agree that this is fraud. We can, but the courts won't call this fraud, unfortunately. So you couldn't really use this as your argument when it comes to debt discharge. Okay. This is where economic truth and the legal truth parallel. Here's the economic truth. You fund the loan. But the legal truth is that the system is going to treat the bank as a lender because of structure, records, and recognition. Both truths exist. One is how the game works, and the other is how the game is ruled. That's why your structure matters. I always talk about this being a game. You don't have to like the game, but if you learn how to play the game, you could play the game effectively. You can play the game the same exact way the banks are playing the game too. I mean, you can't be a bank, okay? So let's just talk about one case that proves the concept. Now, I've talked about First National Bank versus Daly, Jerome Daly, okay? So in this case, and we talked about this, all right? This was a foreclosure case where they was attempting to foreclose on Jerome Daly's property for non-payment of the mortgage. Long story short, his defense was that the bank haven't actually loaned him money, but has simply created credit on the books. Okay, so he used that argument, right? From that, in the first court, the judge ruled that as no consideration because the bank created credit from the borrower's signature. That ruling, though, however, was just in a, what court was it in? It was in a justice of peace, okay? And in the justice of peace, that ruling, it does, you know what I mean? Like it just doesn't have as much weight, okay? It's not precedented, unfortunately. But it did confirm the fact that, number one, the bank created credit from the borrower's signature, and that was considered no consideration. So the judge ruled that to be true. However, even though it's not precedented, what happened was it ended up getting appealed, okay, to a higher court. And in that higher court, what happened was it was some mishaps. Long story short, you know, the lawyer that was working with him ended up, you know, or not, the judge from the Justice of Peace, he ended up dying, you know. So I don't know how that works. I may have to do a separate video on that, but, you know, long story short, they was able to appeal and the bank was able to win because they're trying to say that, I can't remember when, I had to find it, but I think it was just saying that how he tried to do it was just like fraudulent or whatever the case may be. And this is a case that nobody talks about because it confirmed the fact that a judge ruled it to be no consideration. So the law did get behind it. Okay, we're gonna have to figure out why the justice of peace, if it was the fact that he died, why it didn't stand. But don't get discouraged. Even though the system buried the case, it still proves that the logic remains. This is in 1968. All right. Why would he be able to bring that into question in 1968? Now, this was his primary defense. If he went through a defense of what I'm about to talk about, then he probably would have had a better chance of winning. Now, what do you do with this knowledge? You don't scream fraud. You don't shout conspiracy. You use structure, documentation, and the law to create leverage. Okay? Even though we can understand that consideration plays a huge value when it comes to contracts, is one of the primary contractual principles that are needed to be upheld in order for a contract to be proper. You got to understand how to properly structure, how to be able to extract documentation that will put them in a situation where they violate the laws, or they have violated your rights, which you can prove and paint the narrative that they are wronging you, that they are being unjust, that they aren't following the contract, that you didn't breach the contract, why you brought up a question, why you stopped paying. You see where I'm going here? It's not a reason you don't want to lead with equity. You want to lead with the statutes, and then the equity is just going to enhance your argument, because the question to be, why now? Well, literally because I feel like this isn't even an equitable partnership, and that's consideration. All right. Now, if you want to learn more, in the next episode, I'll expose the banking engine itself, how they monetize your signature, and why the system ignores the economic truth. You want to stick around for the entire series, because if you truly want to know how to effectively use consideration in your battle against them, how to properly discharge debt, how to properly use private banking, how to properly fix your credit, position yourself to be able to fund yourself, you want to make sure to hit the like button, hit the subscribe button, turn on those post notifications, because every day this week I'm going to drop a video. You feel me? Until this 5-part series is done, and the next week we on to something different. All right. Thank y'all for watching the video. I love y'all, and I'll see you in the next one.